Today we will revisit all the 12 sessions what was conducted earlier during this session, especially in the morning 6 to 8 a.m. And the first two sessions videos is not available on the YouTube. Isn't it, Ajay ji?
Yes, sir, they were not earlier.
First two is not available. But let me start from first up to till the last. And after that, I have one announcement that I will elaborately discuss on that particular part. On tomorrow, we do not have any session. Number one, tomorrow we do not have any session, and the next part of the session will start from 1st of May and it will go up to the 10th of May. But in the evening, 8:30 to 9:30 or 9 to 10, whatever would be convenient as per consensus of us. First 5 days would be dedicated for drafting, and next 5 sessions would be dedicated for the leading. But meanwhile, today we have achieved at least one landmark which is concerned regarding the jurisdiction of all the cases, jurisdiction of the Supreme Court, including the general jurisdictions, what we discussed. So let us start from first agenda. What was first we discussed with this two-page agenda. The first page was confined to the resources available on the Supreme Court website and otherwise for the purpose of AoR examination. So let me revisit quickly on the link. On this page, I provided a link for the Supreme Court website concerned to the AoR examination. Specifically, this AoR examination stuffs are available on the Supreme Court website. Another link what I shared, it was the 5 years consequent, just previous 5 years question paper, that is 2023, 2022, 2021, 2019 and 2018. 2020 because of COVID, there was no any AoR examination during those periods. And I strongly believe that all the 5 years questions is sufficient for preparation of AoR examination this time. So that's why the question paper is available on the link. If I will click on any one link, it would directly revisit to the particular question paper from the Supreme Court website. Third link was concerned to certain research resources which is broadly available on Supreme Court website. These are the very authentic documents. Out of them, certain things are there: DGSCR, ESCR, and all the judgments. The first link is talking about soft copy of the Constitution of India in English. Another copy, another link is concerned to the soft copy of Constitution of India in various languages, various local languages, which is available on Government of India website, that is called legislative.gov.in. Third is concerned to the DGSCR available on Supreme Court website. Fourth is the judgments and e-courts and so on and so forth. Latest development is here, the main Supreme Court chronicle. Now, let us come to the fourth part, which is concerned to and especially focused for the purpose of AoR examination. Out of them, the Supreme Court rules are there. Supreme Court rules 2013 is very effective and in force these days. But earlier was the Supreme Court Rules 1966. Both are available on the Supreme Court website and the link is there. Otherwise, without link, you can also find out. Another is this Handbook of Practice and Procedure, which I demonstrated repetitively almost every session. Now, the one important link is there, the Constitution of Supreme Court of India. What it is precisely available on the Supreme Court website. If I will click it, probably it will go on the link. Does this screen is available to you?
No, sir.
No, it is not there. That's what it is
Yes,
not
sir.
available. But if you will click, you will find out only 2 and 3 pages are there where the Supreme Court is talking about the Constitution, very precisely the role of judiciary, the Constitution of Supreme Court, or even how registries work, and the very precisely Constitution's concerned part is available here. But anyway, the second link D on this part D. This link is talking about the jurisdiction of the Supreme Court. You can check it by clicking on them. If you will click on them, there are just 2 and 3 pages descriptions written there regarding Supreme Court jurisdiction. Precisely written there Supreme Court jurisdiction, and we broadly discussed about the Supreme Court jurisdiction. So my request is kindly visit on that so that you can find out what is the Supreme Court jurisdiction. Let me just close this particular part. And all these statutes are available in the Government of India website, that is called www.indiacode.nic.in. Now, fifth part is the important part, what I always referred for the purpose of the study and reference. This is chapter 4, the Union Judiciary, which is the extract of Shorter Constitution of India, 15th edition by D.D. Basu, running from page number 735 to page number 913. But I already shared some extract of this particular pages in between. And chapter 1 of the book's Practice and Procedure by Venkatramani, which is talking about the jurisdiction only, and some others document and research paper what I shared. It was the first part of the first session what we discussed and demonstrated. This is just a revisit, nothing new into them. But the another point what we discussed, it was on the another page, which is prerequisite doctrines and underlying principles. And during those part, we especially focused on what was the source, what is the nature, what was the scope and ambit. Sometimes limitations also. And one more parameter ultimately we added, that is called the conditions. Conditions. And we just compiled almost 25 points, which is very important to understand for the not only for the purpose of examination, but also for the purpose of entire professional life. Out of them, just I will read out the points. Dispute resolution mechanism, jurisdiction and powers, what we deal in last 5 sessions. What is the meaning and differences between the courts, court of record, tribunals, and other adjudication forums? What is the meaning of extraordinary jurisdiction and ordinary jurisdiction, and what is the similarity and differences? What is this inherent powers? That's called the extraordinary jurisdiction. Doctrine of merger we didn't discuss on this forum, but we will discuss it very soon. Discretionary power and mandatory power. What is this discretionary and mandatory power? What is the differences? What is the similarities and all? Principles of natural justice. What is the meaning of just, fair, and reasonableness? What is the meaning of manifest arbitrariness? What is the meaning of doctrine of proportionality test? We didn't discuss all these things, especially from 6 to 11 and 12. We didn't discuss. But we will discuss in coming course of time, and especially in the leading cases discussion, during the leading cases discussion. Now, the next part is, and most important part is, we especially focus on the facts of the cases when we are talking about case to case. So we already demonstrated from CPC order 14 what is the meaning of fact and what is the meaning of material fact and what is exact meaning of cause of action, which is a set of fact which discloses certain dispute, rights, liability, and infringement, isn't it? Then, out of this fact and material facts, which comprises necessarily cause of action, whatever the disputed facts on pleading produced by the both parties in the form of plaint or written submission, it comes out the issues and charges, which is the set of questions which need to be determined by the court. Court means any court or adjudication forum. So the disputed part, it need to be determined with the help of evidence, documents, etc. So this issues was the very important, which comprises exactly the set of questions. That questions may be the question of fact, maybe the question of law, maybe the substantial question of law, maybe the mixed question of fact and law, and it may be also the question of as interpretation to the constitution or general importance or otherwise. So especially we will not entering into the question of fact concerned to the issues. It is case to case basis, but certain questions having very general importance and a very general nature, which is affecting the entire nation's law, law in force, and that is the question of fact, question of law, and substantial question. Our focus point is rigorously on these two. What is this question of law and what is this question, substantial question of law? Let me recall the all these three. What is this question of fact, question of law, and substantial question of law? Question of fact is the disputed fact which is determined by the court, and the question of law is on the proved set of fact which law is applicable, up to what extent. But once law itself under dispute, then it is required to determine that disputed law by way of interpretation of the statutes or constitution by the court, an authorized court and concerned court, that disputed questions regarding the provision of law or legal principle or interpretational principle is called the substantial question of law, which is generally leading towards leading cases or reputable judgment, because its nature is very general, concerned to the interpretation of law. So this is the important part, and which is opening a windows for the reported judgment and for the purpose of leading cases, landmark judgment, etc. etc. Now, the one more doctrine is the important, this is the doctrine of res judicata and res integra. Once concerned to this particular cause of action and issues, once all the necessary and sufficient issues is dealt in a particular case, then it would not be a written basis, it will be open only. And that is called the res judicata, doctrine of res judicata. But when something is not something pertinent, important, and a relevant question of law, fact, or substantial question of law is not determined or less, then it is need to be determined, which is called res integra. Now, we rigorously focus on remedial provision of law, which is maybe the extraordinary, like Article 32, Article 136.
Just one moment, sir. Vasanta ji, kindly mute your mic.
Thank you. Thank you. Next, we already visited the revisional provision of law, which is comes through the Constitution. We can say the Article 131, Article 132, Article 133, Article 134, Article 137. We rigorously discussed and focused on. Sometimes we have also discussed, especially in the transfer petition, Article 139A, which is coming from Constitution itself. But at the same time, for the purpose of transfer, two more section is there, which is 406 of CRPC and section 25 of CPC, which is coming under a remedial provision of law ordinary course. Now, various law, duty, and lawyers we will discuss in the professional ethics, administration of justice. It is also the part of professional ethics, Article 129, as well as we will discuss, we not discuss it elaborately and properly. Now, the standard of proof and burden of proof and evidence is a part of entire adjudication process, which is coming from the Evidence Act and principle of natural justice also supplemented with that. So, this we will discuss. It is concerned to the evidentiary values, parameters, and stages. And finally, presumption power, adjudicating authority के presumption powers क्या हैं? We already discuss sometimes and time to time as and when required. Do you have any questions regarding this slide? Because after this break, I'm going to close this part. Something we discussed, something in pipeline, we will certainly discuss during the course of discussion further. Anyone?
All good, sir.
Should I close this one?
Yes, sir.
Yes, sir. Now, after very next day, we take up properly, rigorously, and fairly into Article 141, which is talking about law declared by the court is binding on all authorities. We especially focused on what is core part, which is leading to a particular judgment into the reportable judgment or landmark judgment. And that part is flow from the reasoning of the judgment. And there are possibilities the reasoning may be necessary and sufficient, which is very optimized. In another words, we can say the well reasoned. Another is, it also might be possible some extra reasonings is there which is not required. But another things are there, might be possible, certain reasoning which was required to discuss properly, which missed out after due discussion. And one more possibilities was there, is there, and that is, this is also possible that is some aspect which was need to be discussed as a part of a region, but it was skipped by mistake, not considered totally. And because of that, that reasoning is not optimized and complete. So good judgment is called. So every case is having their own name. Especially मैं थोड़ा सा इसको मैं थोड़ा deliberately इसको डिस्कस करूं एंड स्लाइड्स पे आऊं तो आप ये देखेंगे yes there are certain terms which is called ratio descendi, obiter dicta, parenturium, subsilencio, and others. So ratio descendi is the foundational reasoning of a judgment on which the question is determined. That is called the ratio descendi, and that only part is a law declared. That sequence of reasoning, foundational reasoning for determination of any question is called the ratio descendi, or especially for the substantial question of. So if I will talk about the standard of judgment based on reasonings, and that reasonings itself called the ratio. Sometimes it is called the ratio descendi. So it comes through various forms, either stare decisis, which is comes through the culture, and well settled principle. Meaning of law declared is directly leading to the reasoning of this judgment, and this reasonings is only the binding precedent. It is also called the ratio descendi, but something extra discussion on the judgment which was as a part of the reasoning, which is not required. That is called the obiter dicta, and this is the court jurisdiction which can declare this obiter dicta. Per interim, something is missing. Not considered. Sub silencio is something is unintentionally missing, which need to be discussed during the course of the judgment. And accordingly, the classification of judgment as per the relevance under Article 141, something is called reported judgment, where substantial question of law is there, something interpretation of law or constitution is there, it must be reported because it is the part of law which is having a nature of general objective or general purpose. Non-reported judgment, which is not discussed, something interpretation of judgment, but the verdict is binding on the parties only. So this is concerned to the two parties in this and confined to this party only. So this was not reported, and almost 80% judgments covers under this region, and the rest 20% is going into not 20%. This is the ratio of the 90-10 almost. So leading cases is those judgment which is creating something new or something landmarks that interpretation on the part of interpretation of constitution, provision of law, or principle of law, etc., or something emerged. Or some leading cases are those which are literally landmarks set, either interpretational principle or otherwise, or interpretation of the statutes. It happens very rarely, and very impactful things are there. So, certain terminology is being used during the judgment, that is called the terminology frequently used in the judgment. That word is the ultravirus. I'm not going deep down into all these parts, but everyone is aware about that. Set aside, overruling, referred, relied on, followed, approved, affirmed, distinguished, and others. Every terminology or phrase or words having their own meaning and significance. Once we will enter into leading cases, and during the course of discussion, we will again revisit and understand this part deliberately. Now, we also had during discussion earlier, the main important part was what is the difference. The word I am just emphasizing the differences, very minute differences we trying to capture during the discussions, because it gives us the clarity on the particular point. On what parameter these are the difference. For example, I just taken this word, the differences between the law declared by the competent court of law, one part, and another is law made by the competent legislation. So, what is the differences between the law declaration and what is the differences between the law made? At particular parameter source, who can do that, or who is the competent person or authority or body to declare law, and who is the competent authority or body to make law? It is clearly legislation as per the constitutional mandate, and law declaration which comes through the interpretation. So certainly it is coming on the part of the court, competent court. So this is the important part. What I want to point out, be focused and keep in mind once we are talking about the law declared, it is declaration by the court, and which may be in terms of either ultra virus or set aside or otherwise or putting into the words. But once we are talking about the law made, so the lawmaker, the competent authorities, it goes to the competent authorities. For example, Article 145 is visited to the Supreme Court of India for the purpose of subordinate legislation for Supreme Court. We already elaborately discussed into that. So, after understanding the differences between the law declared and law made by the competent authority, we will again focus on very minutely on the nature, scope, ambit, and constant and limitation. That means sometimes both are the common part is the law, something is made by the legislator, and something is declared by the court during the course of interpretation. So, does it possible some declaration having the nature of legislation? I mean, crossing the limit from first to another. But it might be possible in another case it is crossing the limit to the first one. Adjudication nature. So this was the one part which is covered under the limitation and constraints, scope and embed, and especially the nature of each two, which clearly distinguish on these two. And another is the amendment process. Amendment process specifically for law made, which is laid down on the law, concerned provision of law and the constitution also. But once law is declared, what is the amendment process? amendment process is either set aside or overruling, or is there any confusion? This is going into the distinguished. If this is clear clarity, this is going to the relied on or followed or approved from time to time, or sometimes it is referred. All these words, excepted this ultra virus, is confined to law declared. However, this ultra virus is confined to the law made. So, what is the amendment process for law declared by the Supreme Court under Article 141? And that process is discussed into the Order 6 of the Supreme Court rules by way of constituting a larger bench. Larger means larger to what? Larger to the declared law bench. Sometimes it is happening two judges bench, larger is three. Sometimes it is happening three judges bench, larger is five, seven, and nine, and so on and so forth. Then we need to discuss, we already discussed, we will again discuss the SCR HNPA. This is short notes given by me. Please do not use into the examination, but its meaning are the Supreme Court rules, Supreme Court reporters, head notes, pattern analysis, and its live demonstration. So this PA is confined to the HNPA, head notes, pattern analysis, so that, and this is the very important part, so that during the examination of paper 4 leading cases, so all the compilation of all the 64 leading cases head notes of the SCR, it would be provided into the examination to every examiner. So if we are well prepared, so this is a particular judgment at this particular place, and in this particular sequence certain things are available. So as per question, we can also go there, consult them without memorizing the entire judgment and taking pressure of the memorization. We can use that head notes during the examination for the purpose of reference or consultation, or sometimes something reproduction also. So my point is here, and the only confined to how to use optimally this head notes during the course of examination, and how we should prepare regarding the head notes. So it's a little bit a technical part, so we will focus on that again. We already discussed, but once again we will focus and will discuss before starting the leading cases. Am I clear up to this point or no? So
Yes, sir.
let us quickly revisit again, and also the one part, how we can use this head notes exactly for the purpose of drafting, and drafting ingredients skill, how to develop the summary of facts, how to develop a question of law, what is the reasoning, and reasoning is leading to the grounds, conclusion, ultimate direction is leading to the prayer. So this is a mapping somewhere. Judgment and drafting is not much difference, but the pattern and order are well standard and well set, which is ultimately optimize the process of adjudication, either your drafting or the judgment. If somewhere is lacking in any manner, either in judgment or in drafting, it is the disturbing for us. If drafting lacking something, disorganization or reshuffling in the organization, it disturbs the thought process of the court, and once judgment missing certain important reasoning, it is disturbing for the nation. So both are interrelated, supplementing to each other, and the foundation for the judgment is our pleadings, which is the draft. So don't think this is a much more difference between the judgment writing and drafting in terms of the structure, not in the content. Content is the verdict by the court. We are just seeking and praying for the court, to the court for the relief by way of drafting. So let us quickly revisit on the first part now. So Article 141 was the law declared by the Supreme Court. So we already discussed what is the law and what is the law declared by the Supreme Court and shall be binding. The nature of mandate, once it is shall, binding on all courts. On whom? The all courts. Does this courts, all courts, Supreme Court is cover, or Supreme Court can depart? And if it can, on in what extent and which manner within the territory of India? We also read with Article 142, Article 144, 145.2, 145.3, 145.4, and 144.5. Read with Order 6 of the Supreme Court rules and Order 14 of the CPC, which is talking about the issues. We already demonstrated, the material is available on Google Drive. कहें हिंदी में तो अजय जी के सौजन्य से. So this is the part. Even two points we elaborately discussed. It was the judgment processing life cycle. It is started from number one, which is called pleadings and remedial provision to the court, and ends with the judgment. So this is a connection of starts and ends. It starts from your pleadings, ends with judge's pen. Start with your pen and ends with judge's. So for this purpose, we just discuss and planted one the tea making process. चाय बनाने के क्या method है? It's a very simplest process which I analog to understand this process. And underlying principle of tea making process was what is the raw materials, what is the tools, what is the techniques, expertise, and production. Again, I would like to repeat it, this tea making process for one moment. For those who joined later, once we wish to make a tea, there is a process. First, collect the raw materials. Once I'm talking about the raw material means what? This is only one time usable in this process, and that is the water, milk, certain amount of energy, that is called the gas or electricity, but and etc. Even leaf and all. But certain things is required to prepare, that is called the tools, like pan, stove. These are those tools which is repetitively being used for different purpose. It's not one time, it's a reusable, but it's a required stuff. Without this, we cannot think that we will make it. So the one part is the raw material, another part was the tools, and after that certain techniques is required. And techniques I discuss in the form of certain the set process. पहले ये करना है, after that we will put into this, after that we will put into that, and then observe it, and after some time just take it up. So these are the techniques to develop a tea. But it is set principle, standard principle, but it is not necessarily being followed exactly by the performer who is making the tea. So that goes into the expertise, which is the another term that is called expertise. So I want to distinguish between the techniques and expertise. So the techniques is the set procedure, which is the procedure laid down in the CRPC and otherwise, similarly the tea making process or anything process, but need not mandatorily this process may be followed. It may be little bit changed, depend on the expertise of the person to person. So that is properly exercised by a particular professionals. So this expertise is professional centric process, and techniques is law centric process, which is standard, maybe little bit up and down, but objective should not be disturbed. To meet the objective जो मुझे चाय पीनी है चाय के लिए we are just exercising all this process, but ultimately after exercising all this process what we are getting one product that is called the tea or coffee or etc. So what is the tea? It is a product. So my point is this. So for the purpose of this life cycle, yani judgment processing life cycle, here is the raw material is the fact of the cases, cause of action into them, pleadings, which leaded to issues, which attract certain evidence, and process for proving and disproving them, and ultimately, after producing the evidence, the court determines its issues answer and it is ended with that. So for that particular purpose, raw material is evidence and facts of the cases, cause of actions. Tools is the standard procedural tools, principle of natural justice, the standard of proof, burden of proof, presumption, etc., which is available in the Evidence Act and the CRPC, jurisdiction power, etc., etc. And techniques are the procedures, procedural part, what is laid down. And the expertise is, which is day to day exercising into the court on case to case basis. And what is coming outside after all this process, that is the judgment of that particular case, which is called product. What I want to say, during all these process, raw materials, tools, techniques, expertise of product. So the output, what I am saying is the product, it also may be one time usable, that is called the raw material, or it may be a tools. You know, after making certain process, we are pot makers are making a pot, and pot is reusable. So this product is reusable itself. It falls into the category of tools. And certain things are there. What we are discussing here, how to crack the exam, which cannot show in tangible form, but it's intangible in mind. So these are the techniques which is based into the expertise. And what you people will perform into the exam, that is your expertise. Techniques, what we can provide, we can discuss, which is intangible, which cannot give you right now, but you have to realize it, you have to learn it. So something, this is the intellectual part. And out of them, you will perform into the exam and get the result. Hopefully all result will be positive. So this is the mapping of this process for either into the AoR exam or adjudication system or case-to-case basis. So always once we are discussing, we just keep in mind all these steps where we are shifting from in how manner and where is the problem. Either in tools having the problematic or the techniques having the problematic. If it is, then it should improve, or certain optimized techniques are there, then it would be incorporated. So during the judgment under Article 141, especially under Article 141, so either there is certain tools are there which is very new, or certain techniques are evolved to deal with certain kind of cases, or it, no, we will talk these two only. We will not go into the expertise because this is a professional centric. So we can say this is a very good lawyer and this is a very good judge or bad judge. This comes to the expertise. So I'm not going into that. So either in process or tools. Certain principles are evolved. These are the tools. Certain techniques are evolved. These are the tools. So this is only these two is leading to the reported part for the purpose of interpretation. Am I clear up to this point or not?
Yes, sir.
Yes, sir.
Is there any doubt on this particular part?
No, sir.
So quickly go to the point two. What is the standard structure of the judgment and its ingredient? So brief material facts. Material facts means disputed facts only. Leave all the fact which is admitted part. I am not going to discuss because there is no dispute. So dispute we have to resolve. So no need to go and discuss all the admitted part. So let us find out and pick up only the brief material fact precisely. Issues involved, then come up on the issues. And the doctrine of res judicata and res integrata is there. So be careful on that particular part. Contention of the parties, this is also recorded into the judgment. So all these are the part of judgment. Brief material fact, issues involved, contention of the parties, which party is saying what, and analysis of fact in issues. Just imagine, just imagine in a particular judgment, all these ingredients should be available for the sake of understanding, for the sake of goodness and good judgment, and well reasoned judgment, we can say. But it is also possible, just imagine certain situation when cases are there, but brief fact is not there. Does this convenient to understand the case? No. Just imagine everything is there and this issues is missing. How would you think about that? It would be just uncomfortable to read that book. Something is missing, and which is inevitable part of the judgment, which should not miss, isn't it? So even doctrine of res judicata and integra, contention is not there. This is a great source of dispute. If the contention is not there, especially the fairness part is missing, or ambiguity is imputing in this judgment. So this should be there. And another way, the analysis of fact in issues on the basis of law and ultimately the result. So B point is summarization, analysis of the relevant provision of law as well as existing and applicable legal principles. Legal principle is also required, which is neither written into the judgment, sorry, neither written into the provision of law, but it is coming through the judgments. That means these are the most of the legal principles are coming through judge centric or juristic centric. This is the standard part. Now, proper logical reasoning, what we discussed already, optimally recorded to reach up to conclusion of each issues under consideration, evolution, extension. See, what is this evolution extension? Something is exist and we want to disturb for what and why? For the purpose of either evolution something or in extension or certain things clarification regarding what which clears the doubt. certain part of additional legal principles regarding either law or legal principles, doctrine or maxim which is required, and which certainly comes under these two categories: tools and techniques through product.
Just one moment, sir. Mr. Patel, Mr. B.N. Patel. Thank you.
So, under the light of this particular point one, if we need something, realizing during the course of case, then it is certainly moving towards the leading cases, because this is in the form of maybe evolution, extension, clarification of what? Of what? Clarification, extension, and modification or evolution in existing law. And which law comes from two parts, either in part of law made or in part of law declared. Is there any doubt and modification required or optimization required? That must be reported and informed to the nation by way of Article 141, and it's called the leading case. Something sometimes is a very minute changes is there, but sometimes something is evolved. Like Maneka Gandhi watertight compartment of interpretation of constitution was gone, and another principle of interpretation of constitution was incorporated. So it was certain something was evolved. But certain some tree is there. Either you can add a leaf into that tree, or you can add a complete branch into them. This is again called the improvement, and it must be informed to the nation through, in terms of adjudication, through the judgment. Just I created an analog for the tree, with the tree, which is a growing part, like our adjudication system, or this is the organic part, which is growing from time to time and situation. So it was elaborately discussed, properly discussed, already discussed on 9th March, and I guess अजय जी इसका वीडियो हमने अपलोड नहीं किया,
Yes, sir.
or it was the missing. So it will again recreate it into the leading cases part when we will discuss.
Yes, sir.
And especially we will discuss and conclude it on the sixth part, which is head notes, pattern analysis, and its demonstration, so that we can understand which law is available where, which line and which word is important for us, and for the purpose of answering any question, rather than entire judgment. So the concerned part we will, if we will understand this, we will pick up and use it and live it. Am I clear up to that point? Do you
Yes,
have
sir.
anyone have any question in this regard? Right now, just conclude it and settle it.
I believe none, sir.
No. Okay. So let us close this slide also. This is in the part. Now, I'll not speak much more on all these parts. This is again continuation and deep understanding of this particular part, especially for Article 141.
Excuse me, sir.
Yes.
Sir, can you please repeat this judgment processing life cycle start from I to J?
Sir, this is I'm talking about in the next session, which was happened on the 16th March, and this is available on your audio part. Sorry, YouTube. This is available on YouTube. Am I right or wrong, Ajay ji?
Yes, sir.
And this is again recreation of that part, and which is we already discussed the analysis of Article 141, specifically for Article 142, 145 from 2 to 5, Order 6, and pleadings, including a statement of fact, cause of action, and prayers. Precisely, we discuss into that, and again we discuss the judgment life cycle process, which starts from pleading. Now this is much elaborated part of earlier one. Issues framing, analysis, determination, issues, and ends with the final order or judgment. And model is the raw material, tools, techniques, expertise, and output, and the standard structure of the judgment and its mandatory ingredient, which earlier discussed right now. It was the issues in the form of question of fact, question of law, standard, substantial question of law, and which comes from material facts, and this is confined to the advance contentions advance by the parties. Now, this observation and findings is on the part of court, which is analyzing the fact and provision of law as well as the legal principle and norms. And then finally, determination started on the basis of supported and necessary, with necessary and sufficient reasoning, which may be resulted into, maybe I am using the word not necessary always, evolution. Something is required and interpreted, extension, clarification, addition of legal principle, etc. if required, which is recognized as pleading cases. Wherever it is available in substantial form, this is recognized as pleading cases. And its first video in our YouTube is available on this particular part only. And the conclusion comes through prayer either allowed, denied, or partly allowed, or certain comes with the direction. We also discussed properly and fairly with supported reference analysis of judgment under Article 142. Here should be 141. On the basis of reasoning let down, and that is quality of judgment, even if quality is not there, something, there is a life of judgment. Have you heard this term? We discussed with our sister sir. I invited him for today's discussion. If he can also throw some light on that particular part. But I guess around 7:30 he will join. So have you heard this word? Okay, what is the life of judgment? Some bad judgment has to go. So its life should be small. If larger period of time, that would be in force. Disaster it may be. So sometimes certain judgment is being overruled. Sometimes certain judgment is being modified or declared per inferior. So these are the life of judgment, which is depend on certain things. Another part is the standard of judgment, which is called doctrine of stare decisis, law declared, binding precedent, ratio decidendi, obiter dicta, per inferium, sub silentio, and others. So all these part is confined to taking the first word QLSJ, that is QLSOJ, quality, life, standard, and standard of judgment. So that's what this is, the analysis of judgment under Article 141, on the basis of the reasoning laid down. And that's what the importance of the reasoning laid down. Logical reasoning, not prejudice, but standard. So, for the purpose of entire point, I just made certain words QLSOJ, which is not in existence, but for our understanding, I'm not going to repeat the entire thing. I'll produce this word somewhere, just you understand. This is for you and me. This is the coded word for you and me. कि आप मैं बोलूं और आप उसको समझे या आप बोले मैं ये हमारा कोडेड है बट बी अवेयर कि आप इस वर्ड को एग्जाम में नहीं लिखते अदरवाइज डिजास्टर so this is the things so इस स्लाइड के बाद हमारा इलेबोरेटेड मैंने ढंग से डिस्कस किया हुआ प्रॉपर वीडियो which is available on YouTube started from first YouTube video. Ajay ji, am I right or wrong?
Yes, sir.
Should I
S1E1.
close? Yes, sir. So should I close this slide or is there any question on that?
Not for me, sir.
145 का क्लास 4 and 5 समझना था दोबारा
145 plus
145 का क्लास 5 and 4 and 5
clause 2 to 5, ma'am. 140, yes, this is a very interesting part.
नहीं 2 to 5 2 to समझ आ गई 4 and 5 नहीं समझ आया मैं तो उसका
Okay.
So judgment
We will come back again. We will come back again into the leading phases. But I'd like to show you what you are saying and so to the very important part is this what is pointing out. Let us come to the 145. But you need to remember the only one part. This is the 145 which
judgment pronounced 4 and 5 is judgment pronounced
just
that I
coming
couldn't
one
get
by one. Coming on one by one. So one is talking about the rule making power and this is certain extension with this legislative power. This is the law declaration power. This is 2 which is the subject to the provision of clause 3. Clause 3 ka provision rules made under this article may fix the minimum number of judges which is available in order 6 of the Supreme Court who are to sit for any purpose and may be provided for the purpose of single judges and division court. So to exercising this part order 6 is dedicated there. This is concerned to this part only. And clause 3 saying the minimum number of judges who are to sit for the purpose of deciding any cases involving, this is the condition started. What involving? A substantial question of law. All substantial question of law? No, certain condition is more there. As to the interpretation of constitution. Only, you know what you are raising this constitution article 14 interpretation is required. That is not sufficient. If court convince really this article interpretation is required, need to address, they will frame issue. Once issue is framed, now argument on that part by both parties and analysis would start. So all the matter, see there is 2 points. One point is what we are moving to pleading and what court is satisfied and entered into the different order. In this particular part, I am talking and constitution is talking about the another page when court is convinced. Certain part of interpretation is required. Certain part of constitutional interpretation is required. And this is not only one condition, the condition is one more. Or only 2 conditions is there. First condition involving Either a substantial question of law is this, or for the purpose of hearing any reference under Article 140 shall be by what shall be the minimum number of this. So that's what it is called constitutional bench. Five and more is always called the is coming from this particular Article 3. This bench is constituted for the purpose of interpretation of Constitution. Am I clear up to this point or not? Why this is saying Constitution bench and all? Now the 9 judges bench, Constitution bench is going on. So if I enter into the another one, just I am going to the fourth one. Proviso is there, I am not going into them. And fourth is talking about judgment delivery. No judgment shall be delivered by the Supreme Court. So all the broader part is being seized, and only Windows is available through save. Means except these, all root are closed. So finally, no judgment shall be delivered by the Supreme Court, save, except the only available option is in open court, and no report shall be made under Article 143, save in accordance with an opinion also delivered in open court. So the ultimate part is this: what was the save? Judgment will announce one and only in open court, either judgment or report. Am I clear up to this point or not?
Yes, sir.
No. What is not understandable, ma'am?
Like says that no, the first part says that just remove these. First part of it says that there no judgment shall be delivered by this. That means no judgment shall be delivered by this parent. He has decided and is.
What is the meaning of this? No judgment shall means mandatory be delivered by the Supreme Court. Just say me the meaning of this part of this part.
This part shows that whatever they have decided is substantial question of law or anything, so that judgment should not be delivered in by the Supreme Court in the open court. What I could get.
No, said not delivered in the open court. Then what is the meaning of save?
Save you said except in open court.
बस then what बचा मैंने क्या हटा क्या रहा? सेव वर्ड यदि हटा दें तो कोई जजमेंट ही डिलीवर नहीं हो पाएगा.
अच्छा.
लेकिन यदि सेव लगाए तो किसको हमने सेव किया? ओपन कोर्ट को सेव किया, अदरवाइज सारे ऑप्शन क्लोज. Am I clear up to this point or not?
ठीक है, right.
हमने सिर्फ उसी को सेव किया, ओपन कोर्ट के अलावा और किसी मोड से कोई भी जजमेंट डिलीवर नहीं हो सकता. खत्म बात. तो हमने बचा करके पकड़ के रखा है, संभाल करके रखा है वो ओपन कोर्ट. ये नहीं कि आप रिटनली दे दें, लिख करके आप दे दें बिना कोर्ट में प्रोनाउंस किए हुए.
Except in open court.
ये अपलोड करके, दैट इज नॉट अलाउड. तो हमने सिर्फ उसको बचा रखा है. ओपन कोर्ट में ही कुल मिलाकर के यदि मैं कहूं आइदर रिपोर्ट और जजमेंट वन एंड ओनली ओपन कोर्ट में प्रोनाउंस किया जा सकता है, अदर किसी मोड से नहीं किया जा सकता. Am I clear up to this point or not, or is there any confusion?
No, right. Got it.
So that's the magic of the word save.
Save. That is, I was getting save.
And again, another option is also there, which is coming from the Constitution. No judgment and no such opinion shall be delivered by the Supreme Court. Save. Again, saving is there for the another purpose, and the purpose is with the concurrence of the majority of the judges present at the hearing of the case, but nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. तो स्प्लिट ऑफ ओपिनियन जब होता है तो वहां मेजोरिटी एंड माइनॉरिटी की बात होगी और उसका प्रिवेंशन नहीं है. So every judges are free to express their own opinion. So now the process of clubbing will start. Either it may be fall into the majority, and not only this majority minority. The word is written there, save with the concurrence. So majority, minority, and concurrence. Concurrence either with the majority or minority, isn't it? So the independence of judges' intellectual mind and judicial mind is open there, not restricted, and that part is saved. वो प्रोनाउंस कर सकते हैं. ऐसा नहीं है कि सारा एनानिमस ही होगा. माइनॉरिटी भी हो सकती है, मेजॉरिटी भी हो सकती है, कंकरेंट जजमेंट भी हो सकती है.
So in short, what we mean that whatever will be the decision of the court, whatever the will be the judgment, that
मान
should
लेते
be
हैं
in the open court.
एक सिचुएशन क्रिएट करते हैं. मान लेते हैं कि 5 जजेस बेंच, 2 जजेस बेंच बैठे हुए, दोनों स्प्लिट ऑफ ओपिनियन. एक अलग रीजनिंग से जजमेंट प्रोनाउंस करना चाहती है, दूसरा अलग रीजनिंग से प्रोनाउंस करना चाहता है, लेकिन दोनों एक ही ये कंक्लूजन पे पहुंच गए. यानी रीजनिंग अलग अलग लेना, उन्हें लॉ डिक्लेरेशन अलग अलग, तो वो कंकरेंट जजमेंट हो जाएगा. और ये भी पॉसिबल है कि पहले जजेस ने जो लिखा, दूसरा जजेस कहता है यस इट इज करेक्ट. दोनों के ओपिनियन आइडेंटिकली मैप करते हैं, दूसरे को लिखने की जरूरत नहीं, वो एक ही को फॉर्म करता है, साइन कर देता है दोनों. तो मेन प्रॉपर जजमेंट हो गया. या फिर ये भी संभावना है कि दोनों जजमेंट डिफरेंट रीजनिंग भी है और डिफरेंट कंक्लूजन भी. एक का क्वेश्चन का आंसर या अफर्मेटिव है, दूसरे का नेगेटिव. ये स्प्लिट जजमेंट हो गया. लेकिन जब 5 का बेंच हो या 3 का बेंच हो, तो संभावना ये है कि 2 एक साइड हो और एक दूसरे साइड. तो उसमें मेजॉरिटी एंड माइनॉरिटी ऑब्वियसली खिल करके आएगा. 5 के जजमेंट की बात करें, 2 जजेस कहते हैं ये जजमेंट, तीसरा ऑन सर्टेन रीजनिंग, तीसरा जज ये कहता है योर कंक्लूजन इज करेक्ट बट रीजनिंग आई एम सप्लीमेंटिंग. आपने जो रीजनिंग दिया उसमें मैं थोड़ा सा और ऐड कर देना. तो एक और कंकरेंट जजमेंट आएगा बट लिमिटेड रीजनिंग के साथ. और एक जज ये कहता है कि नहीं, आई एम नॉट कंकरिंग बट आई एम जस्ट अपोजिट. वो माइनॉरिटी जजमेंट हो जाएगा क्योंकि 3 एक साथ अलाइन हो गया. So n number of permutation combination is available. So according to permutation and combination, the fate of the judgment is there, but the सारे जजेस के पास इंडिपेंडेंस है कि वो अपना एक अलग रीजनिंग, आइदर इट मे बी मेजॉरिटी और माइनॉरिटी, इट मे बी कंकरेंट, दे कैन प्रोड्यूस, एंड व्हिच इज सेव्ड बाय आर्टिकल 145(5). Am I clear up to this point or not?
Clear. Good.
Okay, Ajay ji, any
Yes.
more questions or should I close this?
I believe we can close, sir, if anybody has to ask anything.
Okay. Now come back to the particular point 2 to 5 and this slides was done. अब मैं बहुत ज्यादा नहीं जाऊंगा. नेक्स्ट डिस्कशन पॉइंट वाज द वेरी इंपॉर्टेंट पार्ट, एंड उसको मैं सजेस्ट करूंगा कि आप एक बार और डिस्कस करें. इट वाज डिस्कस द डिफरेंस बिटवीन द ऑर्डिनरी एंड एक्स्ट्राऑर्डिनरी जुरिडिक्शन. इट वाज आल्सो डिस्कस द एनालिसिस ऑफ द डिफरेंस बिटवीन एक्सप्रेस एंड इनहेरेंट जुरिडिक्शन. व्हाट इज द डिफरेंस बिटवीन द कोर्ट ऑफ रिकॉर्ड and court of last resort, which is the Supreme Court? What is the tribunals? ADRs means alternate dispute resolution, that is called the arbitration, mediation, conciliation and lok adalat. We elaborately discuss the differences between them. Differences between Original jurisdiction, appellate jurisdiction, review jurisdiction, revision jurisdiction, and difference jurisdiction. If you can recall, सही है ना जी?
Yes, sir.
हिंदू मैम कब रिव्यू होगा, कब रिवीजन होगा, कब अपील होगा और कब ओरिजिनल होगा, हमने बड़े प्यार से इस चीज को डिस्कस किया था और we expended 2 hours for that particular purpose. We already discussed the inherent jurisdiction analysis, especially reference jurisdictional analysis, extraordinary appellate jurisdiction, which is 136 and
136.
227, and extraordinary original jurisdiction 226, 32, etc. कॉन्स्टिट्यूशनल जुरिडिक्शन जो अब बहुत क्लियरली खिल करके आ जाएगा, ये पार्ट जरा आप ध्यान से देखिए, स्पेशली ई कॉन्स्टिट्यूशनल जुरिडिक्शन, कॉन्स्टिट्यूशनल सिविल क्रिमिनल एपलेट जुरिडिक्शन, स्टैट्यूटरी सिविल क्रिमिनल एंड एपलेट जुरिडिक्शन। लास्ट 2-3 मीटिंग से आप मैप करें, आपको समझ में आ जाएगा कि हमने इस पॉइंट पे कितना टाइम दिया है और उसकी क्लैरिटी थी।
Yes, sir.
Yes, sir.
है ना? और अब हम इस वर्ड के थ्रू हम समझ सकते हैं कि हम क्या कह रहे हैं। So this understanding we developed. Further, we also discussed substantial part. Now we entered after through all the remedial provision, especially into the substantial part of provision of law, conditional part of the provision of law, procedural part of the provision of law, jurisdictional part of the provision of law, and remedial part. Am I clear up to this point or not? So in the light of all these 5, we read through Article 32, 226, read with 226 and comparison is also there, 129 and 142 is left, which we will discuss for the drafting. Article 136, Article 139, read with Section 25, read with Section 406 of CRPC, and Article 136. Is there any doubt on that particular part? Video is already there.
No doubt, sir.
So we already discussed and understand this particular part carefully, properly, and deep down, article to article. Let us move to the another part, and after that we discussed the structural analysis and demonstration of Supreme Court rules. We dedicated the 2 interaction session for that particular purpose. Interrelations, relevance of Article 145(1) and Supreme Court rules, and which was aims from this particular Article 145(1), and this was the very small part is this. Subject to provision of any law made by the Parliament, the Supreme Court may, from time to time, with the approval of President, make this necessary condition is there, with the approval of President. Make rules. Who make rules? The Supreme Court. The word is may. And what was the subject? Subject to provision of law, any law made by the Parliament, which is not made or made in some times. For what? For regulating generality practice procedure of the court, including rules as to person practicing before the court. और इसी में हमने वो अल्फाबेट AEIO इंसर्ट किया था, D जो अपोजिट था वो इंसर्ट किया था, जो एप्लेट पार्ट से कंसर्न था, C कंसर्न किया था हमने ओरिजिनल पार्ट से. Did you remember all these things?
Yes, sir.
सर वैसे भी कर सकते हैं. फर्स्ट A B C 3 A's, then 5 C's, then High Court, then
because B and इसका opposite D है, which is talking about appeal.
appeal.
Things are there. C and C, which is the original jurisdiction. C is talking about the part 3 and C is the TP, and which is dedicated to this particular part is dedicated to order 38 of the Supreme Court rules, and this particularly is dedicated to 39, 40 and 41. Am I clear up to this point or not?
Yes, sir.
तो ये सारी बातें थी, बाकी आप लोगों को याद आ गया होगा, मैं थोड़ा सा जस्ट लिंक करना चाहता हूँ. So this we discussed, or even though 9 parts, 4 schedules, 56 orders, ये स्ट्रक्चर है सुप्रीम कोर्ट रूल्स का जो आया है 145(1) के थ्रू. Then we focused on the special focus on selected 17 orders. Out of them, 7 orders was the most important. Objective was concerned to the article से हमने शुरू किया था, rules पे आए, regulation पे, notification and order. So complete process को हमने realize किया था. This video is already available on YouTube. And through this part, Supreme Court jurisdiction from statutes in jurisdiction, specific jurisdictional analysis के थ्रू, जिसमें हमने देखा था कि सुप्रीम कोर्ट के आर्टिकल के थ्रू भी जुरिडिक्शन है, and enlargement of criminal appellate jurisdiction 17, how this is incorporated into the Supreme Court rules to regulate contempt proceedings, regulation regarding AoR examinations and all. हमने स्पेसिफिकली फोकस किया था AoR एग्जामिनेशन, सुप्रीम कोर्ट से ऑर्डर 4 का रूल 5 and 6 को पिकअप किया था, और उसके बाद कॉन्स्टिट्यूशन के वो पार्ट पिकअप किए थे, एंड देन वी डिस्कस. डिड यू रिमेंबर ऑल दिस पार्ट?
Yes, sir.
So it was the another part what we discussed, how these are connected with all these things. This part was left, again reproduction from previous part. Now we are came into the advanced part, general part 1 to 15. इस स्लाइड पे मैं बहुत ज्यादा नहीं बोलूंगा, आप लोग खुद ही देख लीजिए, क्योंकि वो 17 आर्टिकल पिकअप करने थे, वो हमने यहाँ से पिकअप किया. एंड नाउ द मोस्ट इम्पोर्टेंट पार्ट, हमने ये पहला पॉइंट है जो अभी अभी मैं फिर से मैं रिपीट करूंगा. सोर्सेस, पावर, सोर्सेस में कॉन्स्टिट्यूशनल, स्टैट्यूटरी, रूल्स, रेगुलेशन, अथॉरिटी, ऑर्डर. कहाँ से सोर्स है किसी भी अथॉरिटी का पावर का? जुरिडिक्शन. पावर कहाँ से है, पावर क्या है, देन जुरिडिक्शन क्या है, कंडीशंस क्या क्या है, राइट्स क्या क्या है, रेमेडी कैसे है, और उसके प्रोसीजर क्या रहता है. Again we discuss the res judicata, court fees and limitation appearing on the particular rules and regulation, और ये कहाँ से आ रहे हैं. क्योंकि इसी लाइट में res judicata के भी यदि मैं बात करूं, तो या फिर कोर्ट फीस की बात करूं, या मैं लिमिटेशन की बात करूं, ये सारी चीजें हम ऊपर 1 से मैप करते हैं. ये कहाँ से, ये कहाँ, मेरी res judicata कहाँ लिखा है, कोर्ट फीस कहाँ लिखा हुआ है, कितना देना है वो कहाँ लिखा हुआ है, लिमिटेशन कहाँ लिखा हुआ है. हर जगह आपको रूल्स रेगुलेशन में ये सारा कुछ मिलता है. एक्स्ट्राऑर्डिनरी एपलेट जुरिडिक्शन हमने एलिबरेटली डिस्कस किया था, जिसमें हमने एसएलपी सिविल, एसएलपी क्रिमिनल, अपील अंडर आर्टिकल 132, 133, 134, इवन स्टैट्यूटरी सिविल अपील, एंड ऑर्डर 19, 20, 23, 24 ये भी डिस्कस किया था. बट सारे ऑर्डर्स हमने डिस्कस किए थे अपील के, और 19, 20, 21, 22, 23 एंड 20, बिकॉज यहाँ से ये दोनों पार्ट हमने यहाँ ले रखा है, 19, 20, 21, 22 यहाँ ले रखा है. बट ये सारा कुछ एपलेट जुरिडिक्शन को एलिबरेटली हमने डिस्कस किया. देन वी नीड टू डिस्कस दिस ओरिजिनल जुरिडिक्शन. सूट्स के मटेरियल हमने आपको प्रोवाइड करा लिया. इन दोनों के लिए 2 सुप्रीम कोर्ट रूल्स ऑर्डर है, आर्बिट्रेशन है, ये हमने रीड आउट नहीं किया है. और इस पर्टिकुलर पार्ट को, ट्रांसफर पिटिशन को, हमने बहुत क्लियरली एंड प्रॉपर्ली इसको लास्ट डिस्कस.
Yes, sir.
नाउ आई वुड लाइक टू शो यू समथिंग रिगार्डिंग आर्टिकल 32 जो हमने डिस्कस तो किया है, बट वी विल डिस्कस इट अगेन एंड अगेन एंड अगेन विथ ऑर्डर 38 जो आपके लिए छोड़ रखा है. I would like to something throw on light on this particular part, which is the PIL. This is not written into the Constitution. ये jurisdiction ही कहीं नहीं लिखा. और इसके लिए हमने एक जजमेंट के सर्टेन कॉपीज फ्लोट किए थे आप लोगों के पास. It was the 10 pages part. You can see this part. And this judgment is specifically, name is, citation is 2010 1 SCR 678. Cow's title is State of Uttaranchal versus Balwant Singh Chauhal and others. This Balwant Singh Chauhal is an advocate. It was registered before Supreme Court Civil Appeal number 11342 1135 of 2002, and the judgment pronounced on January 18, 2010, and by a double bench headed by, presided by Justice, then and there Justice Talveer Bhandari and Mukundakam Sarma. This is a very good judgment which is talking about the PIL. ये एक्सट्रैक्ट मैं आपके साथ शेयर करूंगा आफ्टर दिस डिस्कशन और प्रोबेबली बाय इवनिंग. एंड इसने पूरे PIL के सिग्निफिकेंस को डिस्कस किया हुआ. इटैलिक पार्ट है, इस पर मैं फिर से वापस जाना चाहता हूँ, इसलिए अभी मैं आपको परेशान नहीं करूंगा. सिर्फ इसका एक पर्टिकुलर पार्ट जो मैं आपको दिखाना चाह रहा था और वो ये था, खास करके दिस पर्टिकुलर पॉइंट 2. इसके पेज नंबर 2 पे आप देखेंगे, here is the 2.1 and here is the 2.2 and here is available 2.4. सिर्फ आप इसका 2 वाला पॉइंट आप जरूर पढ़ेंगे, which says what is the PIL, and definition of the PIL is first time laid down in this judgment, that is called People's Union for Democratic Rights and others. People's Union of Democratic Rights and others versus Union of India and others. आप जरा एक चीज देखिए, ये जो ऑर्गेनाइजेशन है पीपल्स यूनियन फॉर डेमोक्रेटिक राइट्स, ये एक ऑर्गेनाइजेशन है जो PIL फाइल करती है, जो फाइट करती है पब्लिक के राइट्स के लिए, और इनके राइट्स पे ही ओपिनियन यहाँ पर बिल्डअप होकर क्या है. ऐसे बहुत सारे ऑर्गेनाइजेशन है जिनका कंट्रीब्यूशन है सिटीजन्स के लाइफ पे और इवन ऑन कॉन्स्टिट्यूशन पे. उसमें ये फर्स्ट टाइम 1982 में ये लेट डाउन क्रिस्टलाइज किया गया था डेफिनेशन ऑफ दिस PIL. Public interest litigation has been defined. The word I am emphasizing is the defined by this code, and here is certain star is there, and that star is also there. Match it, map it. You got it. So, the PIL has been defined by this code as, and definition is started from here, a cooperative and collaborative effort. Cooperative means एक दूसरे को cooperate करते हो. Collaborative means थोड़ा तुम करो थोड़ा मैं करता हूँ. कोशिश है ये, as a cooperative and collaborative effort by the petitioner, the state and public authority and the judiciary. फिर से मैं रिपीट करता हूँ, PIL has been defined by this code as a cooperative or collaborative effort by the petitioner, the state or public authority, the state or public authority, another entity and the judiciary. 3 यूनिट का कोऑपरेटिव एंड कोलैबोरेटिव एफर्ट्स है PIL. एक यूनिट है पिटिशनर, ट्रायंगल के एक एंड पे पिटिशनर खड़ा है, दूसरे एंड पे स्टेट और पब्लिक अथॉरिटी है, अथॉरिटी कंसर्न बाय द लॉ, एंड तीसरे एंड पे जुडिशियरी है. ये तीनों का कोऑपरेटिव एंड कलेक्टिव एफर्ट्स है. फॉर व्हाट? टू objective is here to secure observance of the constitutional, number 1, or basic human rights for benefits and privileges upon poorer, downtrodden and vulnerable section of society. Usually PIL लोकस स्टैंडाई का लिबरलाइजेशन, यूजुअली वही आदमी केस लेकर के आ सकता है जो एग्रीव्ड है। यहाँ पर वो आदमी केस लेकर के आ रहा है जो एग्रीव्ड नहीं, दूसरे का एग्रीव्ड में राइट इन्फ्रिंज हो रहा है उसके बिहाफ पे, क्योंकि वो कोर्ट अप्रोच नहीं कर सकता, इसलिए एक तीसरा पर्सन जो कोर्ट अप्रोच कर सकता है वो कोर्ट को बता रहा है कि देखो फंडामेंटल राइट इन्फ्रिंज हो रहा है इन गरीबों का और ये अनएक्सेसिबल लोगों का और उनको रिलीफ की जरूरत है, एंड कोर्ट इज ड्यूटी बाउंड टू रिस्टोर देयर fundamental rights and basic human rights. So that's what this exercise is going on. तो कुल मिलाकर के एक डेफिनेशन है और उस डेफिनेशन पे कंप्लीट कमेंट्री है और पूरा एक्सप्लेनेशन है आपका 2.2, 2.3, 2.4 और इवन 2. और तीसरा पॉइंट जो इम्पोर्टेंट पार्ट है, इवोल्यूशन ऑफ पीआईएल। पीआईएल के 3 फेजेस का डिस्कशन यहाँ पर है। यहाँ पर आप देख लीजिए, दिस इज डिस्कस इनटू, दिस इज रिगार्डिंग सेकंड फेज, उसी तरह से थर्ड फेज के बारे में है, तो वो चीज आप देख लीजिएगा। एंड कैसे इसका एब्यूज होता है और कैसे इसको प्रिवेंट करने के लिए होना चाहिए, और इसी जजमेंट के थ्रू आउट पीआईएल एस्टेब्लिश हो गया इन वेरियस साइकिल्स। So this judgment is most important judgment for the purpose of PIL, और इसको समझने के लिए भी ये समझना जरूरी है, ये मैंने आपके लिए नोट किया है और आप इसको जरूर पढ़िएगा, so that we can completely say we are able to understand Article 32 as well as PIL and as well as the Order 38 of the Supreme Court, which is the extraordinary writ remedies available into the Constitution, not only through 32, even also with 2 to 6. And obviously, this is leading for the purpose of drafting. क्योंकि वहां भी 32 writ drafting होती है, PIL drafting होती है, you would be able to distinguish between writ and PIL, क्योंकि उसकी ऑब्जेक्टिव आपको पता होंगे और उसके इंग्रेडिएंट आपको पता है। by way of आपके ऊपर हम लोग छोड़ रहे हैं अभी, और जब केस टू केस हम लोग एलेबोरेटली डिस्कस करें। Am I clear up to this point or not?
Yes, sir.
Yes, sir.
Yes, sir.
अब मैं आपसे ये कह रहा हूं कि अब बताइए, एक सब्सटैंशियल पार्ट ऑफ ओरिजिनल जुरिडिक्शन एज वेल एज एपलेटिव जुरिडिक्शन बहुत प्रॉपरली, बहुत क्लियरली और ढंग से हमने डिस्कस किया है, isn't it?
Yes, sir.
Do we ready to enter into the drafting? क्योंकि all theoretical work is there, हमने वो कर लिया, तो अब हम उसके लिए एंटर करने के लिए रेडी हैं। आज के डिस्कशन को मैं यहीं पे कंक्लूड करूंगा, इस सबको मैं बंद करते हुए, और आपके साथ अभी वापस डिस्कशन मोड में हम लोग एंटर करेंगे। पहले इसको क्लोज कर लें, अब मैं उसके बाद आप लोगों के क्वेश्चन एड्रेस करने के बाद थोड़ा सा मैं अनाउंसमेंट की तरफ लीड करूंगा। हाँ प्लीज।
सर रिपोर्टेबल जजमेंट पे एक बार प्लीज थोड़ा सा ब्रीफ अगर कर देते तो।
रिपोर्टेबल जजमेंट का वीडियो मैम देखिए, अभी तो थोड़ा मुश्किल है, हम लोग लीडिंग केस एंटर करेंगे तब वहां पे करेंगे। आप जस्ट रीड दैट फर्स्ट एंड सेकंड वीडियो, फर्स्ट एंड सेकंड आप जरूर वहां पर मैंने आपको उसको सुने, आपको बहुत क्लैरिटी आएगी, तब डिस्कस करने में हमको अच्छा लगेगा, क्योंकि एनीवे वी विल एंटर इनटू द लीडिंग केसेस, वी नीड टू डिस्कस दैट। ठीक है?
श्योर सर, थैंक यू।
Thank you. Now, one announcement is there. Number 1, tomorrow meeting is cancelled because of election.